This is Common Ground. My name is Sonja Wolf, and with me today is Professor Bill Hing, who is Professor of Law and Migration Studies at the University of San Francisco. And he's also the author of Humanizing Immigration, which is a book we're going to discuss today. Professor Hing has combined community work, litigation, and scholarship throughout his career, and he has been involved in law clinics, for example, the Immigration and Deportation Defense Clinic at the University of San Francisco. Welcome, Professor Hing.
Thank you for the invitation.
So Donald Trump has been reelected recently. He's back in the White House, and he has had an anti-immigration platform. He has also received considerable support from Latino voters, which initially might seem surprising since many of the immigrants in the United States are Latinos. So to get us started, you write in your book that the U.S. immigration system is built on racism and is designed for cruelty towards immigrants and also the dehumanization of immigrants. Could you explain how does this racism manifest in practice?
Well, thank you for the question. In order to understand why I believe that the immigration system is based largely on racism, a bit of history is helpful. And some of your listeners may not realize this, but the very first immigration law in the United States was a law that was directed at excluding Chinese in the late 1800s. It was very explicit, said that Chinese laborers were not allowed to come in. And if you look at the history of that law and the reason for that law, it was racism. That yes, there was some sentiment that Chinese were working for low wages and that they were undercutting the economics of other people in the United States. But it's pretty clear that the language that was used was about racism, that they didn't fit in, Chinese didn't appear to be of the quality that we would want for people to be part of the United States. And so it was clearly racism. And you fast forward a few years, there were laws that were directed even at certain Europeans in the late around 1917 or so. There was something called a provision dealing with English literacy. There was a literacy requirement, not English literacy, and it was directed at Southern and Eastern Europeans that you had to be literate to come into the United States in at least one language. And at the time, there was a lot of anti-Catholicism and also anti-people who were from Eastern Europe. And so that was clearly racist. And then in the 1920s, there was something very explicit that the laws were intended to have national origins quota system. And under that, there was a formula that the largest immigrant groups would come from Western Europe. That would be the favored categories. And so it was clearly racist. And but today, I believe that the big focus of anti-immigration is on Mexico and Central America. When I started practicing immigration law 50 years ago, the sentiment was very anti-Mexican in the 1970s and in the 1980s. That again, the allegations were that Mexicans were coming here and working cheap and that they were criminals. It's kind of very similar to what Donald Trump is saying today, especially when he first ran. He ran around the platform. His very first day that he announced he was running for president before he won in 2016 was saying that Mexicans were rapists and criminals. And so that was just an extension of what was happening for a few decades. And then the border situation during the end of the Obama administration and prominent in the Trump administration most of the people at the border at that time were from Mexico and Central America. And so all the restrictions that were established at that time were to keep those groups from coming in to apply for asylum. And there are a lot of examples that are very technical in the current immigration laws that are very anti-Mexican. For example, it's a crime to enter without inspection. It's a misdemeanor. And at the time that law was passed, the only people that were entering without inspection were Mexicans. There's also a provision, again, this is very technical, that, for example, if you are undocumented and you marry a United States citizen, you would think that it's easy to get lawful permanent residence, but it's not so easy if you entered without inspection. If somebody from Germany came in on a visitor's visa and overstayed for 10 years or 15 years, and then they marry a US citizen, they can apply for their permanent residence without having to leave the country. There's no penalty for them having been an overstayed visitor or student for 10 or 15 years. In contrast, somebody from Mexico who entered without inspection, because they entered without inspection, they cannot complete their paperwork here. There's a requirement that to complete your paperwork here, you have to have one time entered with inspection. And so that person, that hypothetical person, would have to leave the country to apply for an immigrant visa. And by leaving, they're subject to a 10-year bar. Because if you've been here undocumented for more than a year and you leave, you're subject to a 10-year bar. That was clearly directed at Mexicans. So it's very technical, but it's very important in the day-to-day lives of people that are here without status.
We'll go into more examples in a moment, but I wanted to ask you also about a term that you refer to in your book. So it's called crimmigration. It's a term that comes up quite often in analysis of the immigration system and also in the present. What is crimmigration?
Well, crimmigration is a label that's been placed on the fact that there is so much overlap now between immigration status and crimes that there has been developed a specialty of law practice in the United States that combines criminal law practice and immigration law. And in addition to that, what also adds flavor to that term is that more and more provisions in the law make non-citizens criminals. For example, it's up until 15, 20 years ago, there really was not that much of a problem if you used a false document to get a job in the United States. But now that's a crime. Up until a few years ago, if you were convicted of a serious crime, attempted murder, and when I say a few years ago, it's in perspective of how old I am. Prior to 1996, if I represented somebody with a green card, lawful status, who committed a very serious crime like attempted murder, at that person's deportation hearing, I could have asked the judge for forgiveness on behalf of that client if that client had been in the United States as a lawful resident for more than 7 years, and they were remorseful and they had evidence of rehabilitation. The immigration judge had the power to grant a waiver and let that person stay here. Again, had to show that they were remorseful and that they were rehabilitated. It wasn't automatic. But after 1996, somebody with even a minor crime, a minor drug offense, or a minor crime such as, well, relative to murder, a minor crime like robbery or burglary, those people, their deportation hearing lasts 5 minutes because they're usually labeled aggravated felons. And after 1996, I could no longer apply for a waiver of, no matter how remorseful, no matter how rehabilitated, no matter if that person is married to a U.S. citizen and has 4 U.S. citizen children, that person cannot remain in the United States. And so that means that now it's important to know when somebody pleads guilty to a crime. And your listeners should understand that the criminal justice system in the United States, very few people go to trial. Over 90% of criminal cases are resolved by a plea agreement, an agreement that the person will plead guilty. So the drama that we see in movies and television of a trial, that really is not realistic. That doesn't happen. It's usually a bargain that is made. And so if you're representing a non-citizen who is being charged with a crime, then if you're the defense attorney, you better know what is an immigration-friendly plea versus a plea that will get that person in trouble immigration-wise. And that's an example of crimmigration, that that person must not only know what the outcome will be in the criminal case, but that person also has to know the effect of the outcome of the criminal case on that person's immigration status. And so it's become a very specialized area of law. And most criminal lawyers do not know anything about immigration. Most immigration lawyers have never been in a criminal court. And so thus the need for this specialty where people understand both areas of law.
Let's look more closely now at some of the examples that you give in your book. And I'd like to start with the issue of deportation, specifically deportations of lawful permanent residents. So there's something that is called aggravated felonies. And I suppose individuals in the United States who support deportations, even of lawful permanent residents, would say, oh, but these immigrants have broken the law. Of course, they should be deported. But when we look at this, it's actually more complicated. So could you explain what is an aggravated felony and what does this mean for a lawful permanent resident when that person gets classified as an aggravated felon?
Right. So being classified as an aggravated felon is the kiss of death, because that's the example of someone who I alluded to a minute ago, where their deportation hearing would only last a few minutes, depending on what their criminal conviction was. Let me give you examples of an aggravated felony that I hope that most of your listeners would agree with me is too harsh to deport. There was a construction worker who was a non-citizen, and as you may or may not know, at construction sites there are usually portable toilets that are placed on the construction site, and so this one gentleman needed to relieve himself, and so but there were so many workers that were occupying the toilets that he just went behind the construction site and relieved himself. And a passing police officer saw that, okay, and arrested the man and charged the man for indecent exposure, even though there were no children, there were no women around. It was just him by himself when the police officer saw him, okay? And so he pleaded guilty to a misdemeanor of indecent exposure, and that was fine. That was not an aggravated felony, but he was placed on something called probation, that no jail time, but he was on probation for 1 year. And being on probation means you have to behave yourself. Well, as luck would have it, sure thing, a few months later, he did the exact same thing, and another police officer arrested him for the exact same thing, okay, at the exact same circumstances. And he figured, well, you would just plead guilty again, that you're going to be put on probation again, which was true. he was put on probation again, but because it was his second time and it was within his probationary period, it was considered a felony because he did it while he was on probation. That was enough to make it an aggravated felony. That man was deported to Cambodia. His deportation hearing lasted 2 minutes and he was gone. Okay. Another example. It's a sad, well, that's sad because that man actually had a wife and 2 kids. But here's another sad example. And again, I'm not sure if your listeners would agree with. I don't think this example, the person should be deported either. A man was driving his car, and he had a few drinks, and he got into an accident, and his passenger died. Okay, in that accident, and it turns out the passenger was his sister. Okay, so it was very sad, and he was arrested for aggravated drunk driving, and not simple. It wasn't a simple DUI, right? Driving under the influence. It was serious because somebody died. Well, because of that aggravated circumstance, that was considered an aggravated felony, and he got deported. And those were the only 2 children that this family had in the United, that the parents had in the United States. And so they lost both their daughter and their son because of that circumstance. Now, even if your listeners feel that, well, that was pretty bad that somebody died, I wonder if your listeners would agree with, well, let's find out more about this individual before we deport him. In other words, let's provide a hearing where we listen to how this person feels and what he has done and how his parents feel about the circumstances. And the question is, if we provide that opportunity, an opportunity for an immigration judge to grant forgiveness or a waiver, would we be open to that possibility? Not automatic, again, not an automatic granting, but should we be open to at least hearing more? And I hope that your listeners would agree that we should have at least some compassion. Again, not guaranteeing that we will get relief, but we want to at least give a fair hearing to hear the circumstances. Well, if you agree with that, then you would disagree with the current law, because the current law does not even provide for that opportunity to be heard. All the current law provides is it an aggravated felony? So the term is very misleading because it sounds awful. It sounds like kidnapping and murder and rape, but they're not. There are many examples. It can be, again, many people may not agree with what I'm about to say, but possession of certain narcotics for your own personal use, that can also be an aggravated felony. I'm not talking about drug sales. I'm talking about for personal use. That can also be an aggravated felony. But I know that many of your listeners will not agree with what I'm about to say. In my humble opinion, if somebody has lived here lawfully for many years, even if they committed a serious crime, even if they committed murder or sale of drugs, I would still afford that person a hearing. And the reason I feel that way, and I know many of your listeners may not, the reason I feel that way is I have represented people in those circumstances. And especially before 1996, when the law provided such a hearing. And those folks have gone on to live productive lives with families. And so I guess what I'm saying is I believe in redemption, and I believe in forgiveness. And I wish the immigration laws did as well. But we don't. The current U.S. immigration law do not believe in redemption and forgiveness for people that are labeled aggravated felons.
Let's touch briefly on the proportionality of the punishment. So when an aggravated felony has been committed, the punishment may include prison time, also the deportations that we just mentioned, and a prohibition to return to the United States. Does it seem to you that the objective behind this is perhaps not to punish immigrants who are designated as aggravated felons, but simply to expel immigrants from the United States? Certain groups
Yes,
of immigrants?
Yeah, thank you for such a careful reading of the book. I appreciate that. You're absolutely right. And I should have mentioned that when we talk about deporting somebody for a crime in the United States, we're not talking about the ability of that person to forego their prison time by getting deported. Every circumstance I'm talking about, the person has already gone to jail and has satisfied the criminal justice system. And if they had been a U.S. citizen, after completing their prison term, they would be released back into the public. So we're not talking about avoiding their prison time. We're talking about people. It's a double punishment in the sense that you went to prison, you serve your time, and now you get deported. And then the next thing is that if you ever want to come back, like if your spouse and your children want you to immigrate back, you cannot, because you're foreclosed. You're forever foreclosed from returning to the United States. So that's a triple punishment. And I really think that again, I'm not sure if your listeners would agree with this, but a better remedy would be calling a timeout to, if the immigration judge doesn't want to grant a permission or a waiver, well, what about a timeout? What about in the middle of the hearing, the immigration judge says, well, the person has presented enough evidence for me to wonder whether or not he's worthy of permission, but I'm not sure. I am going to call a timeout and basically put the person on probation. And I'm going to have the person report to me regularly, every 4 months or every 6 months, to see how he or she is doing. And after a year or 2 years, then maybe I'll grant the relief. But if they misbehave during that time, well, then I'm going to deport them. And I think that kind of approach would be better. And what's interesting is we use that approach all the time in other contexts in the United States. And the biggest example of that is when crimes have been committed by corporations. So it's a crime, for example, for a car dealer to have cars that their seatbelts always fail, or that the fuel pump is a fire hazard, and it's demonstrated that car company should have known better than doing. Well, what we do in those circumstances, instead of putting the president or the chairman of the board of those corporations in jail, even though it's a crime, we give them what I'm describing. We give them this agreement, a probationary period, for them to behave and to clean up their systems, and then after that, after 5 years, we drop all the criminal charges. And so I think that and those circumstances have caused death to people, but yet we show forgiveness to a corporation, and I think we should show the same type of possible humanity to people.
United States has played a role and continues to play a role in contributing to the conditions in other countries that drive migrants to the United States. At the same time, there are studies that have documented how recent immigrants to the United States often have little choice but to live in impoverished neighborhoods where the conditions in these areas place great stress on immigrant families. Would you say, given this context, that the United States has a moral responsibility to make greater attempts to provide legal pathways to incorporate immigrants into society, to help newcomers adjust to life in the United States?
Yes, absolutely. So the United States, of course, always has its critics within the United States and about the immigration system and the asylum system, and Mr. Trump is one of the biggest examples of that. He complains about Central Americans. He complains about people fleeing the Middle East, and he would have complained back in the 1980s about Southeast Asians coming to the United States. And the problem is, it doesn't take much effort for any individual. You don't have to be a scholar. It doesn't take much effort to learn that the United States fingerprints are all over the world, not just in terms of money, but also in terms of military. And probably the most recent example of that is Afghanistan. That we were there for over a decade, and then we left, and all of a sudden there's all these people from Afghanistan that want to come in as refugees. And when it comes to Central America, it doesn't take much effort to determine that the CIA played a big role in overthrowing governments there and causing disruption, not to mention the multinational U.S. corporations that also our government supported there. And so we have a big responsibility for causing refugee problems around the world. And because of that, I do think that we have a moral responsibility for to accommodate those newcomers. And when they come here, we have an Office of Refugee Resettlement, but first of all, we make it difficult for people to come in. And Mr. Trump is going to be closing the door to refugees from all those different regions of the world that I mentioned. But those who come in, we owe it a responsibility to them to make sure that they're settled in places that are safe. But instead, we often place them in low-income housing and in poor neighborhoods that again re-traumatizes the families, and especially the young kids in those families, that they are harassed and they're in bad neighborhoods, and there's little wonder that many of them actually turn to criminality for protection or for resources. And so again, it's kind of a double victimization of those folks. That they were victimized because of U.S. intervention in different countries, and now when they come to the United States, we don't help them adjust very well. And unfortunately, on refugee resettlement, during the first Trump administration, he reduced refugee resettlement funds to different refugee resettlement programs, and he just announced again that he's doing that again, even though Mr. Biden had increased those funds for refugee resettlement. It's already been announced that refugee resettlement budgets and funds will be reduced again. So I do think that we're shunning a moral responsibility that we have for those folks.
I'd like to turn to undocumented immigrants now, non-criminal undocumented immigrants. People might find it surprising that immigrants might spend many years in the United States without having applied for citizenship through naturalization. Could you remind listeners what the difficulties for undocumented immigrants are? Why might some immigrants not apply for citizenship?
Yes, it's a very important question, because I get that question all the time from anti-immigrant people. They say, well, why don't they just get in line? Why don't they just apply? And it's not that simple. because in order to get lawful status in the United States, you have to have a very close relative or you have to have a very special job skill. And the only relatives that can immigrate to the United States without much problem are those that are spouses of U.S. citizens, the parents of adult U.S. citizens, and the children, the unmarried children of U.S. citizens. And those folks can immigrate pretty much at will, but you have to be in the country lawfully in order to take advantage of that. Then there are other family categories available. For example, for married sons and daughters, or for the siblings of U.S. citizens. And so the problem with those categories is that those categories are subject to numerical limitations. The first three categories are not subject to numerical limitations, but the categories of siblings of U.S. citizens and the married sons and daughters of U.S. citizens, and even the siblings of people with lawful permanent residence, those are subject to quotas. And the backlogs in those categories, in some circumstances, are 15 or 20 years. And so it's not that simple. Even though you have a brother who is a U.S. citizen, the backlog is probably 15 years in that category. So that's a problem. And then for the job skills, you pretty much need to have a skill in technology or science. Yes, there are some other people that can qualify, but the areas for job skills are very limited. It's only 140,000 visas each year in the employment visa categories, and those are used up a lot by places like Silicon Valley and technology around the country. And so there just aren't that many visas available. So it's the average person who is undocumented in the United States does not have relatives of the nature that I just mentioned, or they don't have those kind of job skills. And so there's really no line for them to get in to apply. And there's an estimated 10 to 12 million undocumented immigrants in the United States. And it is true that when we meet people, and we've been meeting many, many people who are afraid right now because Mr. Trump was reelected, and we meet them and we counsel them, my students and I and other volunteer attorneys. Some of them are eligible for a path. Some of them are married to U.S. citizens, or some of them have a U.S. citizen child who will become 21, and that citizen child can petition for the parents. So some of them are eligible for relief, but not that many. It's maybe 10%, 15% might be eligible for something, but the vast majority, they're just here working and trying to make a living for themselves and for their family. They're not criminals, but there's not anything available for them in terms of a pathway to lawful permanent residence, which would, after 5 years of permanent residence, then you could become a citizen. But there's just not a simple pathway.
Undocumented immigrants may be classified as criminal or non-criminal, and there's something that is called prosecutorial discretion. What is it, and how consistently is it applied?
Yeah, so prosecutorial discretion is when either the president or the attorneys that represent the government in deportation proceedings, when they decide, you know what, this person who is eligible to be deported is a nice person, doesn't have a criminal record, has a family here, it is possible for the prosecutor, in other words, the attorney representing the government, it is possible for that prosecutor to say, deporting this person is not a priority. Therefore, I'm going to inform the immigration judge that we are withdrawing our deportation case against these individuals. Now, if the person has been convicted of a crime, the likelihood of that happening is small. It's more likely if the person's been convicted of a crime that the government attorney will proceed with deportation proceedings. But if the person has never been convicted of a crime and has lived here for many years and has citizen children, then up until January 20th, 2025, before Mr. Trump was sworn in, then those people who had no criminal problems, it was fairly easy to convince the prosecutor to just stop the proceedings. But once Mr. Trump took over again, he made it very clear that prosecutorial discretion should not be exercised commonly. And so it's still possible. It's still possible to get it, but it's going to require more, in my opinion, than somebody who is typical. A typical person, again, maybe have lived here for 7 or 8 years or more, and they have citizen children. Those folks, probably prosecutorial discretion would be exercised before Mr. Trump, but probably not now. And what would probably require now is if the children have a very serious illness or something of that nature before prosecutorial discretion would be exercised. And so it's not something that I have confidence in under the new Trump administration.
I'd like to touch on briefly on the hardship requirement. So I understand from what you explain in your book that a deportation might not proceed if it would entail hardship. And then when I looked at the cases you have worked on, it seems that often families are affected by the deportations. And so there are cases where the deportation of one person might mean the loss of health care benefits for the family, for example, or the loss of homes. And of course, there's the family separation. So it seems the impact on the families is serious. What do the authorities mean by hardship then?
Yeah, that's a very good point. In order to satisfy hardship for relief from removal, it's mind-boggling. It requires more than family separation. It requires more than a child with a learning disability. It usually really means that it requires that the child is dying of cancer or has some rare disease. And it's very sad because I gave a similar presentation to a group of pediatricians not that long ago, and I told them that the mere fact that one parent might be separated from the children is not a hardship on the child to satisfy the federal government. And it was mind-boggling to them because there's so many studies that demonstrate that separation from a parent through deportation, but also through imprisonment and, of course, death of the parent. There's studies that show that it's not just emotional hardship that the child suffers. They actually suffer neurological damage that has long-term effect in terms of how they cope with society, how they do in school, what their long-term earnings possibilities are. So every aspect of their life is damaged by separation from a parent, and yet that's not enough. And we're making these arguments before immigration judges, but it's not enough to satisfy them. So it's a long-winded way of saying that the system does not accommodate for regular people who have healthy families and good relationships. The system doesn't accommodate the hardship that would occur when that happens. I do want to say that I have read analogous cases in Europe that go the other direction because of the European commitment to human rights, or the Human Rights Convention that members of the EU have signed on to. That I have read many deportation cases that the European Commission that reviews deportation cases has stopped deportation when there's going to be family separation, even when the person who is subject to deportation has committed several crimes, not just one. And so I do applaud the European Union for a much more humanitarian approach and understanding that family in particular is something that should be valued very highly, even when it comes to removal.
Thank you. Professor Bill Hing, author of Humanizing Immigration. Thank you for your participation. This was episode 1 of the podcast Common Ground, where we talked about the racism of the US immigration system. And we'll be back next week for another episode to talk about immigration courts and the asylum process. Thanks very much.
You're welcome.